Respected Chairman, Vice Chairman, members of Bar Council of Maharashtra and Goa, our resource person for today and tomorrow, Advocate Dr. Sudhakar Avhad sir. I am privileged to have this opportunity to share the strength and introduce Sir Dr. Avhad sir. Sir holds a BSc Honours LLM and PhD in Law. Sir has passed out BSc examination with first class and distinction in the year 1974 from Modern College, Pune. He passed LLB examination in the year 1977 from Pune University, securing first rank at second and third LLB. He passed LLM examination in 1979 from Pune University, securing first rank. He is awarded the Tulpule Gold Medal and other prizes for outstanding performance at law examination. He has been conferred with PhD in law for thesis submitted to the Savitribai Phule Pune University on the topic of global dimensions of human rights and evaluation of fundamental rights under the Indian Constitution. He was chairman of Bar Council of Maharashtra and Goa in the year 2002-2003 and member of Bar Council of Maharashtra and Goa in the year 1998-2003. There are few thousands. There are few thousands advocates practicing throughout India who are his past students, and there are more than 250 judges in Maharashtra state.
Madam, you are not audible.
Being students of coach. Now, sir, am I audible? Am I audible?
Yes, madam, you are audible.
हाँ मॅडम आवाज येतोय.
सरांना आवाज येत नाहीये. सरांना येत नाहीये.
Madam, you are pretty audible.
Has been practicing as a lawyer since 1977, having a standing of around 46 years today. He has practiced on civil, criminal, revenue, and cooperative sides with specialization in land laws. Dr. Avhad sir has written a couple of books for law students. He has written a book titled Draftsman for Practitioners. In fact, latest he has written a book on MCQs for family court exams. I welcome sir and request him to take the topic for the family court exams of Hindu Succession Act. Over to you, sir. Thank you.
Namaskar. Today's subject for the family court judges examination will divide this discussion into two parts. I have been asked by the organizers to divide this discussion into two segments. Today, the discussion as to Hindu Succession Act in general, and tomorrow, same time, to analyze this topic from examination point of view. So, general discussion plus examination aspects are the two components of our discussion as to Hindu Succession Act. Regarding today's subject, from our examination point of view and as a general discussion, let us see this Hindu Succession Act as the word itself is self-explanatory, Succession Act. Friends, here we have to understand first what the term succession means. When there is a property owned by any person, then this property passes from one person to another person by two methods. Either property may pass inter vivos, that is between two living persons. One person transfers his property to another person. This is called as inter vivos between two living persons. This aspect is regulated by the Transfer of Property Act of 1882. However, person, he has his property, nevertheless, he is not transferring it during his lifetime to any person, but he dies without transferring any property. Then issue arises how after his death, his property shall pass on to his heirs. Then there are two methods of this succession. One is testamentary succession and other is intestate succession. Testamentary succession, word testament means a sacred document, pavitra dasta. So this sacred document provides for passing of the property by will of the deceased. This is testamentary succession that is provided in the Indian Succession Act of 1925. Then second part is, that is today's discussion, that is intestate succession. Intestate succession means when a person dies, he has been given a choice by law to make his will, but he has not made any will. Then his property will pass as per the provisions in law. And such property of a Hindu passes as per this act, that is today's subject. Accordingly, this today's subject is to be analyzed by us. This Hindu Succession Act, even though it is said to be intestate, nevertheless, in this law, to some extent, orthodox, textual, and scriptural concept of survivorship is to be discussed. So there are today two parts to be discussed. One is survivorship method and other is succession method. The concept of survivorship as to passing of the property from deceased person to his other persons or heirs is unique as far as Hindus are concerned. And this uniqueness first we have to understand. In case of principle of survivorship that differs from succession, survivorship means if there are four owners and one of such owner dies, then after his death, his estate, his share or his property will not pass to his widow or to his son or to his daughter, but this will pass on to remaining three owners, remaining three joint owners. This is the principle of survivorship. And therefore, we have to understand today principle of survivorship on the one hand and on the other hand, succession as per this act. Survivorship is stated in our textual law in Vedas, Shrutis, Smritis, and various other textual laws. They provide for principle of survivorship. However, the principles of intestate succession are to be found in today's subject. Let us see the combination of the two. And to understand this, we have to go back to Vedas. We have to go back to Manusmriti. We have to go back to two schools of Hindus, that is Mitakshara and Dayabhaga. I will not take you to very elementary discussion because we have got limited 1 hour's period today. During this or within this 1 hour's time, I will explain to you that in case of Hindus, there is a concept called as Hindu joint family, co-parsonary, and Hindu family. Sometimes there is a concept of Hindu undivided family, HUF. Sometimes there is a distinction to be made as to co-parsonary and Hindu undivided family. At the outset, I will explain. Usually, for taxation purposes, the concept of Hindu undivided family is used. However, in case of Hindus, there is a concept of Hindu joint family. In 4 sentences, we can say, what is Hindu joint family? Hindu joint family means it comprises of certain members, common ancestor, descendants from common ancestor, plus wives of the male members, less married daughters. They are the members of Hindu joint family. Members of the Hindu joint family, therefore, are common ancestor, then offsprings from common ancestor, plus wives of the male members coming from other families, and daughters are to be deducted who are given in other families. This is the membership of Hindu joint family. But this alone is not sufficient. For further discussion, that is necessary that such members, they shall be joint in food, joint in residence, and joint in worship. And then only these people, they will constitute Hindu joint family. Therefore, to constitute Hindu joint family, there is no need of any property to be owned by Hindu joint family. Hindu joint family is a natural status. Hindu joint family is a natural status. Anybody born in the family automatically becomes member of the Hindu joint family. There is no need of any property. On the other hand, there is a concept of co-parsonary amongst Hindus. And that co-parsonary is different than Hindu joint family. It differs in its structure from Hindu joint family. This co-parsonary is a creature of law. On one hand, we say that Hindu joint family is a natural status. On the other hand, we say co-parsonary is a creature of law. It is created by law. And therefore, there are four important elements. First, co-parsonary, it consists only of male members. That too within 4 degrees or 4 generations. And there is a need of such 4 members holding ancestral property. And therefore, when such male members within 4 generations holding ancestral property, then only there can be co-parsonary. Co-parsonary is 4 members, 4 generations, but not limited to 4 generations. 4 generations at a time. And therefore, if there is a father, then son and son and son's son. And there is also a further son at the 5th generation. He will not become co-parsonary ipso facto. If father dies, then he will become the 4th generation. Automatically, this is a continuous process. And hence it is said that co-parsonary is a fluid concept. Then this co-parsonary requires ancestral property. And here comes our today's discussion. That in case of Hindu law, in case of Hindu family, in case of Hindu co-parsonary, there are 2 types of properties. As per our scriptural law, as per our textual law, there are 2 types of properties. One is ancestral property and other is separate property. What is ancestral property has been stated that property in the hands of a Hindu coming from his father or father's father's father or father's father's father is ancestral for his son, son's son or son's son's son. Therefore, you will find in case of a Hindu, 3 generations upwards and 3 generations downwards is the scope of ancestral property. Such ancestral property is also called as apratibandha daya as per our textual law or scriptural law or Vedic jurisprudence. Therefore, apratibandha daya means ancestral property that is therefore of a co-parsonary property. Hence, at the outset, I will say, in case of co-parsonary property, only male are the members, only male are the owners, and no female could have any right in respect of such co-parsonary property. And in case of such a co-parsonary property, and in case of a co-parsonary existence, if any of the member died, then what happened? In case of a co-parsonary, there is a community of interest. There is a jointness of the possession and jointness of the ownership. Each part of the property is owned by all, and every part of the property is owned by all. Therefore, there is community of interest in respect of such co-parsonary property, which is owned by all. Then this owned by all means that there is a joint ownership and there is a joint possession. And one of them dies. Say that there are only 4 male members and 4 male members, one of them dies. Today what happens? His widow takes, his daughter takes, his son takes, his mother takes as class 1 heirs. But then before the coming into force of the today's Hindu Succession Act of 1956, what happened? His widow, his mother, his daughter could not take anything. His share, it went back to other co-owners or joint owners, and they took the property. This was the principle known as survivorship. Friends, therefore, to begin this discussion, concept of survivorship must be clear to you. Survivorship means in case of death of a co-partner, his share or his property, or his interest, it goes to surviving co-partners, remaining co-partners, and therefore this is survivorship. Why it is called as survivorship? सर्वायवरशिप म्हणजे काय? शिल्लक राहिलेले बाकीचे मग जर का 4 मालक असतील and one of them dies, त्याच्यातलं एक मेला, काय होईल? Remaining, surviving 3 they will take. Therefore survivorship principle. This survivorship principle was followed for thousands of years, as we have seen. And in this entire process, female had no rights. Female had no rights for centuries together, thousands of years in respect of Hindu system. They had only two rights. Hindu female, she had only two rights in the property. One was Sri Dhana and other was right of maintenance from and within co-parcenary property. Therefore, every family, therefore, it did consist of co-parcenary in past. This continued, and there was no proprietary right of female recognized except these two extent. However, in the run of the time, during British period, there were various laws enacted. And one of such law enacted by the Britishers was Act of 1937. According to me, this is the first law wherein any female or any widow, she could get proprietary rights in case of co-parcenary. She could have right of partition also in respect of co-parcenary property, and that widow's right or woman's right came to be recognized by the Act of 1937, the Hindu Women's Rights to Property Act of 1937. This act provided for rights of a widow. In case of death of husband in co-parcenary before 1937, if husband died, widow had no right except right of maintenance. However, for the first time, by this legislation during British period, there was historic change made. This historic change was that after death of her husband, widow, she could get right in the property that is share of her husband. She was made owner for the first time. However, absolute ownership was not conferred on her. It was provided in the Act of 1937 that after and in the event of death of her husband, such widow, she could be made limited owner. Concept of limited ownership, limited interest came to be introduced for the first time by 1937 legislation. After death of her husband, she became owner of the property, but not absolute. But all right, previously there had been no interest. Now at least she could have limited interest. And during husband's lifetime, she could get nothing. After husband's death, so husband at that time having his interest in Mitakshara co-parcenary, they such widow she could get limited interest within the family. For the first time, she could have a limited interest. She could use it. She could enjoy it, but she could not sell it. That is limited interest. So purpose was that there was some security conferred on such a widow, whereby she could enjoy the property, she could use the property, but she could not alienate the property. She could not sell the property, and therefore this limited interest continued during her lifetime. And after her death, this interest reverted back to some male member in the family again. This reverted back to some co-partner again in the family. That was the structure of 1937 legislation. From nothing to something was the journey up to 1937 legislation. Thereafter, in the year 1947, India became independent. And then in the year 1950, there was the Constitution of India adopted by the Indians in the Constituent Assembly. Thereafter, during that time, there was Hindu Code Bill Committee constituted. When there was Hindu Code Bill Committee constituted under the chairmanship of B.N. Rao, great constitutional expert, who had been also the constitutional advisor to the Constituent Assembly, and thereafter he became the judge in International Court of Justice. He was the first judge of India in International Court of Justice. At that time, therefore, when B.N. Rao, he was constituted as a chairman, and committee was constituted to decide the feasibility, the possibility, and working of codification of Hindu law. Whether there can be, or entire Hindu law, entire Hindu personal law can be codified and can be put under in one book or not. However, this could not be done. There were differences, political reasons, And there were reasons, as we have discussed then, how Nehru, Jawaharlal Nehru, and late Dr. Babasaheb Ambedkar, they differed on their views. And ultimately, Dr. Ambedkar, in disagreement with the then Prime Minister, he resigned from the ministry and also from the membership of Lok Sabha. That was the consequence in respect of this introduction of the bill and the law. However, in the year 1955, the first law was passed, that is the Hindu Marriage Act of 1955. In the year 1956, 3 laws were passed: Hindu Adoptions and Maintenance Act, the Hindu Minority and Guardianship Act, and the Hindu Succession Act of 1956. That is today's subject. This came into force from 17 June 1956. And when this came into force from 17 June 1956, this did consist only of 31 sections. The last section, that is 31st section, that relates to repeals. So there are 1 to 30 sections. Friends, therefore, when you prepare for this examination, you have to understand what is the scope and what is the flow of these sections. What is the interrelationship, interlinking of these various sections in this law. These various sections in this law, they are so arranged, nicely arranged, that first 3 sections, they relate to definition part, application part. Then section 4 of this law relates to overriding effect, that we'll discuss today and tomorrow also. What is overriding effect? A potential question from examination point of view. Then thereafter comes section 6 that decides intestate succession. How intestate succession shall proceed is decided with reference to old section 6 and thereafter the amended section 6. And then section 8 to section 13 provides for Hindu male succession. In case of a Hindu male dying intestate, in case of Hindu male dies without making a will, how after his death his property shall pass on to his class 1 heirs is decided with reference to section 8 to section 13. Then section 14, section 15 and section 16, they relate to the female succession. In case of a death of a female Hindu, how her property shall pass on to her heirs is decided with reference to these 3 provisions. And then section 17 to section 29. Section 17 to section 29, they provide for general principles of Hindu succession. General principles of Hindu succession are to be stated in these sections. And then comes section 30, that is as to testamentary succession. That too has been amended in the year 2005. That also we'll discuss while reading of this entire section series. So this is the provision made of this entire law. To read it properly from examination point of view as well as practice point of view, to become Hindu, to become a family court judge, and also after becoming a family court judge, how to interpret this law. And the mainspring of this law, the importance of this law, friends, is with reference to very few sections. To practice in Hindu law, to prepare for Hindu Law Succession Act, there are very few sections properly to be understood. Section 4 first, then section 6, then section 8, then section 14, then section 19, and then section 30. Any student, any lawyer, any advocate preparing for this examination or otherwise, he understands the interrelationship between these 6 sections, then he completely understands this law. And therefore, let us today try to understand interrelationship between these sections and the other sections, and the examination potentials we postpone it tomorrow. So let us see these chain of sections. Let us see section 4. If examiner requires you to answer a query, or if you are going to the court and you are carrying with you Manusmriti, if you are carrying with you Narada Smriti, you are carrying with you Kautilya's Arthashastra, and you wish that you shall tell the judge, Your Honor, look into this book. Shall judge allow you or not? Whether judge shall allow you to read those scriptural religious books or not. And issue will arise whether to allow you or not. And you will find answer to this is to be found in section 4 of this law. Section 4 of this law means what? Section 4 of this law really decides whether hundreds and thousands of years old Hindu text, religious texts, whether are relevant in today's courts of law or not. While reading Hindu Succession Act, while referring to statutory law, can we refer to the scriptural law or not? आपले हे हजारो वर्षाचे धर्मग्रंथ आपल्याला कोर्टात वाचायला परवानगी आहे काय? आणि ती आहेही आणि नाहीही. काही गोष्टी ती वापरता येते, इतरत्र वापरता येत नाहीत. Where it is said, असं कुठं म्हटलंय कधी वापरा आणि कधी वापरू नका, कधी वापरा आणि कधी वापरू नका. Whether these hundreds of and thousands of years old texts can be read in the courts or not, can be referred by the judges while deciding the cases or not, is to be decided with reference to section 4.
सर माईक जर आपलं 1 मिनिट पॉज करतो. सर सर माईक म्यूट झालाय सर. सर तुमचा माईक म्यूट झालाय, समोर अनम्यूटचं ऑप्शन आलंय, तेवढं फक्त एक करा ना सर. हा.
Am I audible?
यस सर, यस सर.
Can you hear me?
हो सर, येतोय आवाज, येतोय.
Hello.
सर येतोय आवाज, येतोय
Am I
सर.
audible?
यस सर, यस सर. Yes, yes.
So the question is whether past law, uncodified law, law in the books, law in the Vedas, Shrutis is relevant today in the courts or not. And you will find section 4 is the connecting link. Thousands of years old textual law and today's parliament's law are interconnected by section 4. This first we must understand. And for understanding section 4, we have to understand section 4 consists of section 4.1 and section 4 subclause 2. This subclause 2 has been deleted by 2005 amendment. Today there is only section 2.1a and section 2.1b. Of these two provisions, 2a and 2b, let us see the interrelationship. You must understand thoroughly this section. It is only of 3 sentences. Section 4.1a says that any text, any rule, any interpretation of Hindu law, or any usage or any custom of that law, which was in force immediately before commencement of this act, shall cease to exist insofar as there is provision made in this act. इतकं सोपा तो सेक्शन आहे मित्रांनो, की जर का 17 जून 56 पर्यंत आपला कायदा अस्तित्वात आहे आणि त्या अस्तित्वात असलेल्या कायद्यासंबंधाने, जुन्या कायद्यासंबंधाने, म्हणजे कोणचे, एनी टेक्स्ट, एनी रूल, एनी इंटरप्रिटेशन और एनी यूसेज और एनी कस्टम ऑफ ओल्ड लॉ, रादर ओल्ड लॉ, धर्मशास्त्र आणि धर्मसूत्रास लॉ. आणि जर का अशा 5 गोष्टीसाठी जर का आजच्या कायद्यामध्ये, आजच्या ह्या हिंदू सक्सेशन ऍक्ट 1956च्या कायद्यामध्ये जर का त्या संबंधाने काही दुरुस्ती केलेली असेल, काही तरतूद केलेली असेल, काही प्रोव्हिजन केलेली असेल, मग जुना कायदा वाचायचा नाही. सो वी विल नॉट रीड द ओल्ड लॉ, ओनली विल रीड टुडेज लॉ. सो व्हॉट इज द टेस्ट इंटरकनेक्शन? जर का आधीच्या कायद्याच्या ऐवजी आता एक्सप्रेस प्रोव्हिजन केली असेल, देयर इज अ ओव्हरराइडिंग इफेक्ट. Hindu Succession Act shall have overriding effect over the old law. Old law is not to be referred to, is not to be read into. Court will not allow you to refer the old law in the courts. However, if the present law is absent as to any such provisions, then old law will apply. I will ask you a simple question. What is ancestral property? Where is defined? आपण म्हणतो रोज प्रत्येक सेक्शन मध्ये आपण सांगतो, प्रत्येक आर्ग्युमेंट मध्ये आपण सांगतो अँसेस्ट्रल प्रॉपर्टी आणि को-पार्सनरी. आपण जर का हिंदू सक्सेशन ऍक्ट वाचला तर त्याच्यात म्हटले, शब्द वापरलेत, को-पार्सनरी, अँसेस्ट्रल प्रॉपर्टी. कुठे डिफाईन केले? वेदर द हिंदू सक्सेशन ऍक्ट हॅज डिफाईन को-पार्सनरी? नो. मग ही को-पार्सनरीची व्याख्या आपण कुठून घ्यायची? वेदर the concept of ancestral property has been defined in today's law? If it is not defined in today's law, then we have to refer back to the ancient law. That is how, friends, section 4(1)(a) provides for. म्हणजे सेक्शन 4(1)(a) चा आपल्याला असा अर्थ निघाला पाहिजे की जर का त्याविषयी जुना कायदा असेल आणि नवीन कायद्यात तरतूद केलेली असेल तर नवीन वाचायचा, आणि जुना कायदा असेल आणि नवीन कायद्यात तरतूद केलेली नसेल जुना वाचायचा. उदाहरणार्थ अँसेस्ट्रल प्रॉपर्टीची व्याख्या, उदाहरणार्थ को पार्सनरीची व्याख्या. यापेक्षा आणखी एक गोष्ट आपण पाहूया की पार्टिशन. हिंदू कायद्यामध्ये, हिंदू फॅमिलीमध्ये कशा प्रकारे पार्टिशन व्हावं, हू कॅन क्लेम पार्टिशन, हाऊ पार्टिशन कॅन बी क्लेम, व्हॉट इज द प्रॉपर्टी टू बी पार्टिशन, व्हॉट इज रिओपनिंग ऑफ द पार्टिशन, व्हॉट इज रियुनियन इन केस ऑफ पार्टिशन मेंबर्स, वेअर टू फाइंड, वेअर टू बी फाउंड. कशात लिहिलंय हे? हिंदू सक्सेशन ऍक्ट मध्ये लिहिलंय का? कोणत्याही पार्लमेंटच्या कायद्यात हिंदू संबंधाने असं लिहिलं का? नाही. व्हॉट प्रॉपर्टीज टू बी पार्टिशन, देन who can claim partition, how can be claimed, हे कोणत्याही कायद्यात लिहिलेलं नाही. हे हिंदू संबंधाने कुठेही लिहिलेलं नाही. मग जर का ते हिंदू सक्सेशन ऍक्ट मध्ये नसेल, जर का ते पार्लमेंटच्या कायद्यामध्ये नसेल, मग आपण कुठे शोधलं पाहिजे? ओल्ड लॉ. Therefore old law, earlier law, ancient law becomes relevant. That ancient law or the old law will become relevant. म्हणून जर का तुम्ही आज सुप्रीम कोर्टाचं, माननीय सर्वोच्च न्यायालयाचा कोणताही निर्णय पाहिला आणि जर का तो पार्टिशन वरचा असला, जर पार्टिशनच्या खटल्यामध्ये माननीय सर्वोच्च न्यायालय कशासाठी रेफरन्स करत असतात? एंटायर हिंदू धर्मशास्त्राज आणि धर्मसूत्राज, वेदाज आर रिफर्ड, स्मृतीज आर रिफर्ड, श्रुतीज आर रिफर्ड, and therefore there is a reference made in case of partition suit. So partition suits are referred not to Hindu Succession Act but are referred to ancient law. आणि म्हणून जर का मित्रांनो आज तुम्हाला प्रश्न विचारला की भारतामध्ये आता किंवा हिंदूंच्यासाठी आता एन्शियंट लॉ, धर्मशास्त्रातला लॉ लावायचा का लावायचा नाही, तर पार्टिशनसाठी लावायचा, श्रीधनासाठी लावायचा. आणि जर का त्यांनी विचारलं की मेल सक्सेशन साठी लावायचा का, मग नाही लावायचा, बिकॉज देयर इज अ प्रोव्हिजन मेड इन दिस ऍक्ट and therefore this aspect is to be seen that is provided in section 4. Therefore thousands of year old scriptural law and today's law, that is to be seen with this reference. Based on this proposition we'll go to section 6. आणि जुना सेक्शन 6 काय सांगत होता तो बघूया. नवीन सेक्शन 7 आपण बघणारच आहोत. जुना सेक्शन 6 काय सांगत होता? दॅट इज इंटर रिलेटेड. आणि जुना सेक्शन 6 सांगत होता when after coming into force a male Hindu dies in Mitakshara, having his interest in Mitakshara co-parsonary, then his interest shall devolve on the surviving co-parsoners by the principle of survivorship and not as per this act. Provided that if he is survived by any heirs of female heir of class 1 or any male heir claiming through female heir of class 1, then his interest shall devolve as per this act and not by survivorship. So friends, for the first time in this Hindu Succession Act, or for Hindus, two terms came to be coined. One was continuance of co-parsonary, survivorship. पुरुषांची प्रॉपर्टी पुरुषांना जाणार. दिस वॉज सर्वायवरशिप. आणि आता सक्सेशन वापरला आपण या कायद्यामध्ये सेक्शन 6च्या माध्यमातून आपण प्रथमच त्या प्रोव्हिजोच्या माध्यमातून सक्सेशन आणलं. आणि कोणाला? फिमेल हेअर ऑफ क्लास 1. एनी फिमेल हेअर ऑफ क्लास 1 or any male heir claiming through the female heir of class 1, then this act applies. So for application of this law there is a condition precedent. हा कायदा लावण्यासाठी काय कंडिशन घालण्यात आली होती? जर का फक्त पुरुषच असतील मग हा कायदा लागतच नव्हता. जर का फक्त पुरुष मंडळ असेल आणि त्या कुटुंबामध्ये कोणीच फिमेल हेअर्स नसतील, 4च भाऊ असतील किंवा वडिलांचे 4 भाऊ असतील, बाकीचे घटक मयत झालेले असतील, मग त्या कुटुंबामध्ये हिंदू सक्सेशन ऍक्ट लावायचा नाही असं जुना सेक्शन 6 सांगत होता. ओनली दे विल सर्वाइव्ह टू इच अदर, प्रिन्सिपल ऑफ सर्वायवरशिप अँड नॉट द प्रिन्सिपल ऑफ सक्सेशन. हाउएव्हर by proviso, by exception, by limitation, it has been stated in case of death of such a Hindu, if he is survived by female heir of class 1 or any male heir claiming through such female heir of class 1, then his interest shall devolve as per this act and not by survivorship. म्हणजे थोडक्यात इथे त्या पुरुषाच्या नंतर तो हिस्सा मागण्यासाठी जर का नवीन कायद्यात 17 जून 56 पासून आलेल्या कायद्यामध्ये फिमेल हेअर ऑफ क्लास 1 जर असेल तर मग जुना कायदा वापरायचा नाही. thousands of years old law not to be looked into. Therefore, section 6 is another connecting link between thousands of years old law and today's law. जुना सेक्शन 6 जो होता तो 17 जून 56 पासून अंमलात आला होता. तो 94 आणि 2005 सालापर्यंत एक्झिस्टन्स मध्ये होता. तो जुना सेक्शन 6 सांगत होता फक्त फिमेल हेअर ऑफ क्लास 1 असला, फिमेल हेअर ऑफ क्लास 1 असतील किंवा एनी मेल एअर क्लेमिंग थ्रू फिमेल हेअर ऑफ क्लास 1 असतील तरच नवीन कायदा लावायचा, तरच सक्सेशन ऍक्ट लावायचा, नाहीतर जुनाच कायदा लावायचा. म्हणजे थोडक्यात जसं सेक्शन 4 ह्या दोन कायद्यांची सांगड घालतो, जुना कायदा पास्ट लॉ, वेदिक लॉ, टेक्स्च्युअल लॉ आणि पार्लमेंट्स लॉ, तसं सेक्शन 6 पण त्याची सांगड घालत होता की कधी जुना कायदा लावायचा आणि कधी नवीन कायदा लावायचा. नवीन कायदा लावण्यासाठी 56चा कायदा लावण्यासाठी कशाची जरुरी होती? female heir of class 1 or any male heir claiming through female heir of class 1. That was the necessity in respect of section 6. मित्रांनो ही त्याची गरज होती. मग त्याच्या पुढचा सेक्शन आला सेक्शन 8. सेक्शन 8 काय सांगतो आपल्याला? सेक्शन 8 provides for the male succession. If a male Hindu dies after commencement of this act, that is after 17th June 1956, then his interest shall devolve firstly on class 1 heirs. If they are absent, then class 2 heirs. If they are absent, then on agnates. If they are also absent, then on cognates. Are the 4 categories of heirs stated in respect of section 8. In respect of class 1 heirs, there is a very novel principle provided for. The heirs in category of class 1 heirs, they take simultaneously and equally. हे जे class 1 heirs असतात, ते जे वारस असतात, they take simultaneously. ते कोणालाही बाहेर काढत नाहीत, सगळ्यांना तो शेअर मिळत असतो. दॅट इज सेक्शन 8. अँड आफ्टर सेक्शन 8 कम्स सेक्शन 14. Really, if you ask me, sir, of these various sections, which is historic section from female point of view, then I will say section 14. Section 14 is historic. काय आहे असं ऐतिहासिक? मित्रांनो, आपण मगाशी पाहिलं की आपल्या हिंदू धर्मशास्त्राप्रमाणे, वेदांच्या प्रमाणे स्त्रियांना फक्त 2च हक्क होते, स्त्री धन आणि मेंटेनन्स. 37च्या कायद्याने काय दिलं तर लिमिटेड इंटरेस्ट. टू सम एक्सटेंट लाईफ इंटरेस्ट वॉज क्रिएटेड देअर. नाव फॉर द फर्स्ट टाइम ऍब्सोल्यूट इंटरेस्ट वॉज गिव्हन टू हर बाय व्हर्च्यू ऑफ द ऍप्लिकेशन ऑफ सेक्शन 6 रेड विथ सेक्शन 8. शी कुड हॅव नाव ऍब्सोल्यूट इंटरेस्ट. आणि असं कुठं म्हटलं मग आता? हिंदू स्त्रीनं धारण केलेली मालमत्ता ही आता ऍब्सोल्यूट असली पाहिजे, कारण आधी 0. 37च्या कायद्यानं लिमिटेड, ह्या लिमिटेडचं आता ऍब्सोल्यूट मध्ये रूपांतर करणारा सेक्शन म्हणजे सेक्शन 14. सेक्शन 14 therefore provided for transforming such interest into absolute interest, and therefore section 14(1) and section 14(2) are to be understood. Section 14(1) of this act provides any property possessed by a Hindu female acquired before, at or after commencement of this act shall be held by her as absolute property and not as a limited property. म्हणजे थोडक्यात एखाद्या स्त्रीनं, मुलगी असो, लग्न झालेली असो, विधवा असो, कोणीही असो, there is the word used Hindu female, and therefore property held by such Hindu female shall become her absolute property. Only requirement is that property should be possessed by her. त्या स्त्रीच्या ताब्यामध्ये जी जी मालमत्ता असेल, ती मालमत्ता जर का 17 जून 56 तिच्या प्रत्यक्ष ताब्यात असेल किंवा तिला राईट टू पझेस असेल, तर मग ती ऑटोमॅटिकली काय होईल? शी विल बिकम ऍब्सोल्यूट ओनर. म्हणजे थोडक्यात या कायद्याने स्त्रीच्या संपूर्ण मालकी हक्काची, ऍब्सोल्यूट ओनरशिपची कॉन्सेप्ट अंमलात आणली. अँड देअरफॉर दिस इज हिस्टॉरिक सेक्शन. सेक्शन 14(2) सांगतो, जरीही सेक्शन 14(1) न तिला ऍब्सोल्यूट ओनरशिप दिली असली तरी सेक्शन 14(2) असं सांगतो, इन केस ऑफ एनी गिफ्ट और एनी विल, इफ देयर इज अ लिमिटेड इंटरेस्ट ऑलरेडी क्रिएटेड इन हर, देन शी विल कंटिन्यू टू हॅव लिमिटेड इंटरेस्ट. सेक्शन 14(2) असं म्हणतो, मात्र तिला जर का इंटरेस्ट निर्माण करत असतानाच लिमिटेड इंटरेस्ट दिलेला असेल, जो 14(1) मध्ये कव्हर होत नाही, then she will have limited or life interest as may be stated in that will or as may be stated as per those provisions. This is the difference between these two sub clauses of section 14. Thereafter we come to section 19. Section 19 is another interesting provision. आपण नेहमी असं म्हणतो की whether after commencement of this act today co-parsonery exist or not. आता खरंच हिंदूंची को-पार्सनरी अस्तित्वात आहे किंवा नाही. खरं तर 17 जूनला जेव्हा हा कायदा केला तेव्हाच पार्लमेंटला को-पार्सनरी नष्ट करायची होती. ही जी स्त्रियांना हक्क न देणारी अन्यायकारक संस्था होती, ही त्यांना नष्ट करायची होती आणि स्त्रियांना सुद्धा पुरुषांच्या इतकेच हक्क द्यायचे होते. परंतु हे करताना ते टप्प्याटप्प्याने द्यायचे होते. समाजाला ते रुचावं आणि ते समाजात रुजावं म्हणून ते हळूहळू द्यायचं होतं. And therefore, instead of making it one stroke, they have done in different stages. And these different stages where death was the made criteria for. म्हणजे हिंदू को-पार्सनरी संपवण्यासाठी पार्लमेंटने संपवायच्या ऐवजी पार्लमेंटने फक्त एक तरतूद करून टाकली सेक्शन 19 आणि मृत्यू झाला की काय घडेल हे सांगून टाकलं. मृत्यू झाल्याबरोबर हिंदू को-पार्सनरचा मृत्यू झाल्याबरोबर त्याच्या हातात असलेली त्याचा शेअर ह्याचं स्वरूप बदलून जातं. दॅट अँसेस्ट्रल प्रॉपर्टी बिकम्स सेपरेट प्रॉपर्टी. दॅट अँसेस्ट्रल प्रॉपर्टी इन द हँड्स ऑफ अ हिंदू बाय व्हर्च्यू ऑफ ऍप्लिकेशन ऑफ सेक्शन 8 रेड विथ सेक्शन 19 बिकम्स सेपरेट प्रॉपर्टी. मित्रांनो, हे लक्षात घ्या की आपण आधी पाहिलं की ह्या को-पार्सनरीच्या घटकांच्या पुरुषांच्या हातामध्ये ती इस्टेट त्याची अब्सोल्यूट प्रॉपर्टी होती. नाव बाय व्हर्च्यू ऑफ हिज डेथ दॅट अँसेस्ट्रल प्रॉपर्टी, ती वडिलोपार्जित मिळकत आता वडिलोपार्जित राहत नाही. ती का राहत नाही याचं कारण सेक्शन 8 आणि 19. काय आहे हे सेक्शन 19चं मॅजिक ते प्रथम पाहूया. असं काय घडतं त्या सेक्शन 19 मध्ये की ज्याद्वारे ही अँसेस्ट्रल प्रॉपर्टी वडिलोपार्जित मालमत्ता आता ही स्वतंत्र मालमत्ता होते, सेपरेट प्रॉपर्टी होते. हे करण्याचं कारण म्हणजे सेक्शन 19 मध्ये असलेले अ आणि ब असे 2 क्लॉजेस. त्या 2 क्लॉज पैकी एक असं म्हणतो, in the event of death of a Hindu, if there are 2 or more heirs claiming, कोणत्याही हिंदूच्या नंतर जर का त्याला 2 किंवा अधिक वारस असतील आणि ते जर का हिस्से मागत असतील, कसे द्यायचे? एक क्लॉज सांगतो, they shall be given per capita and not per stripes. स्ट्राइप म्हणजे ब्रँच. कोणत्याही हिंदूच्या मृत्यूनंतर त्याच्या वारसाला आता जितकी माणसं असतील म्हणजे डोकी, तितकी डोकी मोजायची, तितके हेड मोजायचे. पर कॅपिटा म्हणजे पर हेड आणि तितक्याला समान हिस्से देऊन टाकायचे. दॅट इज 1 पर कॅपिटा अँड नॉट पर स्ट्राइप्स. पर शाखेप्रमाणे नाही द्यायचं. शाखेत म्हणजे वडील, त्याचा मुलगा, नातू ह्यांना शेअर द्यायचा असं नाही करायचं. जितके हजार असतील त्यांना शेअर देऊन टाकायचं. अँड सेकंडली, हे जे पर हेड दिलेले आहेत प्रत्येकाच्या डोक्याप्रमाणे दिलेले आहेत, प्रत्येक व्यक्तिमत्वाप्रमाणे दिलेले आहेत, ते कसे घेतात? आणि मग खालच्या क्लासमध्ये ते सांगितले. And it is stated further, they take as tenants in common, not as joint tenants. मित्रांनो, ही एक ओळ को-पार्सनरी नष्ट करायला कारणीभूत ठरली. काय म्हणतो सेक्शन 19 दुसरा भाग, such heirs, 2 or more heirs, they take as tenants in common and not as joint tenants. मग आपल्याला आता इथे हे 2 शब्द प्रयोग समजावून घेतले पाहिजे की ज्या 2 शब्द प्रयोगाच्या आधारे को-पार्सनरीचं अस्तित्व नष्ट करण्यात आलं. आणि काय 2 शब्द प्रयोग आहेत, काय 2 इंग्लिश मधले वाक्प्रचार आहेत? एक टेनन्स इन कॉमन आणि जॉईंट टेनन्स. आपल्याला प्रथम हे समजलं पाहिजे टेनन्स इन कॉमन म्हणजे काय आणि जॉईंट टेनन्स म्हणजे काय. जॉईंट टेनन्स म्हणजे काय आपल्याला माहिती आहे. जॉईंट टेनंट हा शब्द भाडेकरू ह्या अर्थानं समजावून घेऊ नका. टेनंट हा शब्द इंग्लिश ज्युरिस्प्रुडन्स मधून आलेला आहे आणि इंग्लिश ज्युरिस्प्रुडन्स मध्ये टेनन्सी या शब्दाचा अर्थ मालकी हक्काचा प्रकार असा होतो. तो जॉईंट टेनन्सी देअरफॉर मीन्स इफ देर आर 4 जॉईंट ओनर्स, then in case of death of one of them, his share will go to the surviving owners. This is called a joint tenancy. जिथं जॉईंट टेनन्सी असते तिथं त्या जॉईंट टेनन्स पैकी जर एकाचा मृत्यू झाला तर त्याचा हिस्सा या बाकीच्या मालकांना मिळतो, त्याच्या वारसांना नाही मिळत. आर यू गेटिंग करेक्टली? आय विल रिपीट अगेन. In case of a joint tenancy, which is the crux of the today's discussion, in case of joint tenancy, this was the peculiar feature of co-parcenery. Death of a co-parcener, others will get. This is joint tenancy. However, the joint tenancy principle, which was followed in India for years together, thousands of years together, has been done away with one stroke. एका फटक्यामध्ये पार्लमेंटनं हे कॅरेक्टर नष्ट करून टाकलं. जॉईंट फॅमिलीचं कॅरेक्टर, जॉईंट फॅमिली प्रॉपर्टीचं कॅरेक्टर, को पार्सनरी प्रॉपर्टीचं कॅरेक्टर नष्ट करून टाकलं. आणि काय केलं? दे आर टेनंट्स इन कॉमन. आता त्यांना तुम्ही जॉईंट टेनंट म्हणायचं नाही, त्यांना म्हणायचं टेनंट्स इन कॉमन. आणि टेनंट्स इन कॉमनचं काय महत्व असतं? इन केस ऑफ जॉईंट टेनंट, इफ एनी ऑफ देम डाईज, देन others will not get, but his heirs will take. काय फरक आहे दोघांच्या मध्ये? जर का जॉईंट टेनन्सी असली तर एकाच्या मृत्यूनंतर बाकीचे घेतात, वारसांना नाही मिळत. आणि जर का कॉमन टेनन्सी असेल तर, टेनन्स इन कॉमन असतील तर एखाद्याच्या मृत्यूनंतर ते बाकीचे नाही घेणार, त्याचे वारस घेतील. दिस इज द डिफरन्स. अँड धिस डिफरन्स नाउ प्रोव्हाइड्स फॉर द कॉन्सिक्वेन्स इन रिस्पेक्ट ऑफ द टर्मिनेशन ऑफ द को-पार्सनरी. आणि म्हणून जिथं जिथं सेक्शन 19 लागतो तिथं तिथं को-पार्सनरी संपुष्टात येते आणि वारसांच्या हातामध्ये ती इस्टेट त्याची सेपरेट प्रॉपर्टी होते. आणि म्हणून सेक्शन 4, सेक्शन 6, सेक्शन 8 read with section 19 makes a complete sense. म्हणजे थोडक्यात 17 जून 56 नंतर एकत्र कुटुंबातील को-पार्सनरीमध्ये असलेल्या एखाद्या को-पार्सनरचा मृत्यू झाला तर त्याच्या मृत्यू पश्चात त्याची इस्टेट ही सेक्शन 8 आणि 19 ने रेग्युलेट करायची. thereby that property in the hands of the heir, that will become his separate property. That was the consequence with reference to these provisions in this Hindu Succession Act. However, in section 30 provides that any Hindu male, आधी फक्त हिंदू मेल शब्द होता, आता मेल आणि फिमेल दोन्ही शब्द आलेत 2005च्या अमेंडमेंटनं. ते सुद्धा परीक्षेसाठी इम्पॉर्टंट आहे. सेक्शन 30 has been amended previously before 2005 amendment. As per section 30, only male Hindu could make will of his undivided share. एखाद्या हिंदू माणसाला को-पार्सनरी मध्ये असलेल्या त्याच्या हिस्सा संबंधानं मृत्यूपत्र करता यायचं. फिमेलला करता येत नव्हतं, डॉटरला करता येत नव्हतं, कारण ती को-पार्सनरच नव्हती. म्हणजे थोडक्यात ती को-पार्सनर नसल्यामुळे तिने तिचा शेअर द्यायचा प्रश्नच येत नव्हता. दॅट वॉज द कॉन्सिक्वेन्स इन रिस्पेक्ट ऑफ स्प्रेड ऑफ दीज सेक्शन्स. या सगळ्या तरतुदीमध्ये एकच दोष होता, आम्ही मुलींना शेअर देऊन टाकला. किती शेअर देऊन टाकला? डॉटर इज मेड क्लास 1 heir, and if she is made a class 1 heir, then issue arises, what is the extent of her share? I will take very simple illustration for today's discussion. Say for instance there is father and there is a son and there is a daughter, only 3 members in the co-parcenery. This is co-parcenery property. At the time of commencement of this act, that is before 1994 and before 2005, daughter could not be co-parcener. ती काही त्या कुटुंबाचा सदस्य होती, जॉईंट फॅमिलीचा सदस्य होती, पण को-पार्सनर काय नव्हती. आणि ही प्रॉपर्टी को-पार्सनरीची आहे. ही को-पार्सनरची असल्यामुळे त्याची डिव्हिजन कशी होईल? अजून कोणाचाच मृत्यू झालेला नाही, ही प्रॉपर्टी को-पार्सनरीची आहे आणि त्यामुळे असं होईल की वडिलांचा अर्धा हिस्सा आणि मुलाचा अर्धा हिस्सा. आणि देन फादर डाईज, वडिलांच्या मृत्यूनंतर काय होईल? हिज हाफ शेअर विल गो टू सन अँड हाफ शेअर विल गो टू डॉटर. म्हणजे मुलाला 2दा शेअर मिळाले. 2दा कसे मिळाले? एक शेअर को-पार्सनर म्हणून अर्धा शेअर मिळाला, वडिलांच्या इतका मिळाला, आणि वडिलांच्या हिश्श्यामध्ये पुन्हा अर्धा शेअर मिळाला. 1/2 of the 1/2 means 1/4. म्हणजे त्या मुलाला एकदा 1/2 को-पार्सनर म्हणून आणि एकदा 1/4 वारस म्हणून त्याला 3/4 शेअर मिळाला. आणि त्या डॉटरला किती मिळाला? ओनली 1/4. म्हणजे या कायद्यानं आमच्या ह्या भगिनींना आम्ही हक्क दिले, परंतु ते हक्क देत असताना या स्वरूपाचे दिले की तिला को-पार्सनर केलेलं नव्हतं. वडिलांच्या हिश्श्यामध्ये भावा इतका हक्क दिलेला होता. म्हणजे भावाला को-पार्सनर म्हणूनही हक्क होता आणि वडिलांचे वारस म्हणूनही हक्क होता. भगिनीला मात्र फक्त वडिलांचे वारस म्हणून हक्क होता. हा ह्या दोघांच्या मधला फरक. दिस वॉज द प्रोव्हिजन मेड. And thereafter, now issue was that this daughter's share to be increased. She shall be made co-parcener. However, till then, there was no such status conferred on her. For the first time, there was a provision made as to law in the state of Kerala. There has been a law enacted in the year 1975, the Kerala Hindu Joint Family Abolition Act 1975. State of Kerala was the first state to abolish co-parsonary concept. तो जो पुरुष प्रधान संस्था होती की ज्या पुरुष प्रधान संस्थेमध्ये पुरुष मंडळ होतं आणि फक्त पुरुष मंडळालाच हे अधिकार असावेत हा कन्सेप्ट केरळाइट हिंदूजनी प्रथम नष्ट करून टाकला. स्टेट ऑफ केरला provided for abolition of co-parsonary and Hindu joint family, and thereby now there is no birth as the criteria. Co-parsonary मध्ये काय होतं, as soon as child is born automatically becomes member and by birth there is the right created. However, now in Kerala right from 1975 there is no right by birth. There is no ancestral property. Every property becomes separate property, and once there is a death of the holder, then succession takes place under Keralite law. This did happen in 1975. Hereafter, daughters or the female, they started claiming rights under this law. And for the first time in the year 86-87 in Andhra Pradesh state. In the year 1990 in the state of Tamil Nadu, in the year 1994, Karnataka, and then on 22nd June 1994, Maharashtra state. Amendment has been made in Hindu Succession Act. When amendment has been made in a Hindu Succession Act, issue arose whether daughter is to be made co-parsoner or not. And by these 4 state laws, daughter is made a co-parsoner. Daughter is made a co-parsoner like that of a son. While doing so, one defect was left. One infirmity was left. It was said that those daughters who are unmarried on the date of the commencement of this act shall become co-parsoners. म्हणजे थोडक्यात आम्ही डॉटरला भावासारखं को-पार्सनर करून टाकलं, पण कोणत्या डॉटरला? Those daughters who were unmarried on the date of the commencement of this act. म्हणजे थोडक्यात 22 जून 1994 ला ज्या मुली अविवाहित होत्या त्या झाल्या को-पार्सनर्स, आणि ज्या मुलींची लग्न 22 जून 1994 च्या आधी झालेली होती त्या मात्र काय को-पार्सनर झाल्या नाहीत. And therefore that discrimination between son and daughter was done away with, but there was a further discrimination between daughter and daughter. बहीण भावांच्या मधला भेदभाव थोड्या अंशाने कमी केला, परंतु बहिणी बहिणींच्या मध्ये आम्ही भेदभाव निर्माण केला. काय भेदभाव निर्माण केला? Married and unmarried daughters. So married and unmarried daughters was the discrimination made. This discrimination continued, and there was now 174th report of the Law Commission of India. Law Commission of India, they provided for amendment in this law. Law Commission of India, along with its 174th report, submitted a draft bill of the amendment. And that has been sanctioned, that has been passed, that has been enacted by the Parliament of India, and that has been transformed into a form of a law effective from 9/9/2005. An issue thereafter arose that this law, whereby daughter is made a co-parsoner from 9/9/2005, whereby daughters have been made co-parsoners, how to be interpreted? Question arose that daughters are made co-parsoners in the same manner as that of a son. They shall have all the rights and liabilities that of a son. Issue arose how to interpret this provision. And just to look into, at the outset, this amended section 6, it starts with a phrase, on and from. It starts with the 2 words only, on and from the commencement of the Hindu Succession into bracket amendment bracket complete act, 2005. A daughter born to a co-parsoner in a mitakshara co-parsonary shall A, become a co-parsoner in her own rights by birth, like a son, and B, shall have all rights that of a son, and C, shall have all the rights and liabilities and duties that of a son. म्हणजे थोडक्यात on and from commencement of this act. आणि ह्या कायद्याची, ह्या अमेंडमेंटची, नवीन सेक्शन 6 ची कमेन्समेंट डेट आम्ही ठरवली 9/9/2005. 9/9/2005 सालापासून, या दिवसापासून त्या कुटुंबामध्ये असलेली ती मुलगी, तिला मुलगाचा समजा, आणि शी शॅल बी मेड को-पार्सनर. कशी? married or unmarried, both. Married or unmarried, both, they are to be treated as co-partners and they shall have all the rights, duties and obligations that of a son. त्यांना सगळ्या पर्पजसाठी, सगळ्या प्रॉपर्टी मॅटरसाठी आता सन म्हणून ट्रीट करायचं. That was the rule made. It was very simple, innocent application. However, in the course of the time, that took a very lengthy passage for its proper interpretation. Issue arose as to interpretation of this provision, which daughter. इतकं सगळ्यात छान तरतुदी झाल्या तरी एक छोटासा प्रश्न उपस्थित झाला, which daughter. तुम्ही मला असं विचारलं, which daughter means daughter. No. Issue arose before the courts. There are 3 types of daughters now. One, daughter born after 992-005. Daughter born after 17th June 1956 to 992-005. And daughter born before 17 June 1956. अशा 3 प्रकारच्या मुलींचं क्लासिफिकेशन करायची वेळ आता कोर्टासमोर आली. का करावं लागलं क्लासिफिकेशन? 17 जून 56 ला काय आलं? द फर्स्ट लेजिस्लेशन, द ऍक्ट ऑफ 1956. त्याच्या आधीची जर एखादी मुलगी जन्मलेली असेल तिला लागेल काय? 17 जून 56 म्हणजे 56चा कायदा आल्यापासून 2005 ची अमेंडमेंट येईपर्यंतच्या ह्या स्पॅन मध्ये जन्मलेल्या मुलींना हा लागू होईल का फक्त हा कायदा फक्त 9/9/2005 नंतर जन्मलेल्या मुलींना लागू होईल? इतका छोटासा प्रश्न कोर्टासमोर उपस्थित झाला. Which daughters are regulated? And came various cases before the courts. I will not go into all those details, not necessitated for you at this stage. But issue was before Karnataka High Court in case of Pushpalata versus Padma and in case of Prakash versus Phulavati. And they have said that this act has got retrospective effect. आधी जन्मलेल्या मुलींना पण दिला पाहिजे. कर्नाटक उच्च न्यायालयाने सांगितलं की 17 जून 56 नंतर जन्मलेल्या मुलींना हा कायदा लागू होईल. However, in Maharashtra, a case arose before Bombay High Court. सदाशिव सकाराम पाटील वर्सेस चंद्रकांत देसले आणि त्या केसमध्ये मुंबई उच्च न्यायालयाच्या समोर प्रश्न उपस्थित झाला की हा कायदा रिट्रोस्पेक्टिव्ह आहे का प्रॉस्पेक्टिव्ह आहे? And it has been held by Bombay High Court that this act is prospective only. This will apply to daughters born after 992-005. Immediately, within a couple of days' time, was a case before Bombay High Court, Vaishali Ganorkar versus Satish Ganorkar. And in this case, again, the Bombay High Court has held that this act is prospective only, not retrospective. Against this decision of Bombay High Court, there was an appeal to the Supreme Court of India. And the Supreme Court dismissed that appeal and said that law point is kept open. As a consequence thereof, law in Maharashtra was different and law in Karnataka was different. There were different laws applicable, different interpretations were applicable in short. And there was no final decision from the Supreme Court. In the meanwhile, there was a further reference to the larger bench before the Bombay High Court. In case of Badrinaran Shankarlal Bhandari versus Om Prakash Shankarlal Bhandari, 2014 Bombay High Court. And ह्या केसमध्ये परत इश्यू निर्माण झाला whether this act is prospective or retrospective. आणि आता मात्र बॉम्बे हायकोर्टानं सांगितलं that this act is partly retrospective and partly retroactive. म्हणजे आधी जन्मलेल्या मुलींना पण हा कायदा लागू होईल असं मुंबई उच्च न्यायालयाने सांगितलं. इतकंच कशाला, मुंबई उच्च न्यायालयाने अत्यंत वायडर इंटरप्रिटेशन काढलं आणि सांगितलं हा कायदा 17 जून 56च्या आधी जन्मलेल्या मुलींना लागू होईल, हा कायदा 17 जून 56 नंतर जन्मलेल्या मुलींना लागू होईल आणि हा कायदा 9/9/2005 नंतर जन्मलेल्या मुलींना पण लागू होईल. ऑल डॉटर्स आर कव्हर्ड ॲज पर बॉम्बे हायकोर्ट डिसिजन. हाउएव्हर देयर वॉज नो डिसिजन फ्रॉम द सुप्रीम कोर्ट ऑफ इंडिया and was a case before the Supreme Court. Was the case of Prakash versus Phulavati. In case of Prakash versus Phulavati, issue was whether act is prospective or retrospective. And the Supreme Court of India, in their 2015, Justice Goyal and other judges of the Supreme Court of India, they have held that this act is prospective only. And all the previous judgments were set aside or overruled by the Honorable Supreme Court, holding that this act is prospective. And it has been observed that on 992-005, 3 things are necessary. This is important from your examination point of view. Firstly, on 992-005, property must be available. On 992-005, daughter must be alive. And on 992-005, the father must be alive. This is triple test to be applied as per the decision in Prakash versus Phulavati 2015 Supreme Court. ही जर केस डिसाईड झाल्याबरोबर एक 5-6 महिन्यामध्ये दुसरी केस उभी राहिली, दानामा वर्सेस अमर अँड अदर्स. या केसमध्ये मात्र देर वॉज अ डेथ ऑफ फादर बिफोर 2005. प्रकाश वर्सेस फुलवतीमध्ये काय सांगितलं, 2005 ला काय पाहिजे, तिघे पाहिजेत, वडील पाहिजेत, मुलगी पाहिजे आणि प्रॉपर्टी पण अवेलेबल पाहिजे. पण आधीच्या केसमध्ये, नंतरच्या ह्या दानामाच्या केसमध्ये कोर्टाने सांगितलं जरीही वडील नसतील तरी चालेल, जर का दावा पेंडिंग असला तरी चालेल. 9/9/2005 ला 2च टेस्ट अप्लाय केल्या, डुअल टेस्ट इन्स्टेड ऑफ ट्रिपल टेस्ट. आधी होतं प्रॉपर्टी, मुलगी पाहिजे, वडील पाहिजे. आता दानामाच्या केसमध्ये कोर्टाने सांगितलं की वडील असायची गरज नाही. फादर need not be alive on 9/9/2005. Only daughter must be alive and property must be available. Immediately within couple of months' time was the third case on the point before the Supreme Court, and that was the case of Mangamal versus T.B. Raju. And in this case, court held that Danama's case is wrongly decided, incorrectly decided, while Prakash versus Pulvati we follow and triple test be applied. Property must be available, daughter must be alive, and father must be alive. And therefore, there were such rather inconsistency between these three judgments of the Honorable Supreme Court of India. And hence came the last case to be discussed. And that was the case from Delhi High Court. Vinita Sharma versus Rakesh Sharma was the case decided by Delhi High Court. And against the decision of the Delhi High Court, there was appeal to the Supreme Court of India. And in this case, before the Supreme Court of India, issue was very simple. Issue was whether this triple test is to be applied or dual test is to be applied. Act is prospective or act is retrospective and retroactive was the question before the Supreme Court. Whether Prakash versus Pulvati is correctly decided or not. And court said Prakash versus Pulvati is overruled. Court further said Mangamal versus T.B. Raju overruled. Case of Danama is partly overruled, and court held thereafter. Court held that this act is not prospective only, this act is retrospective also, and to some extent retroactive also. So this act is applicable to daughters born after 9/9/2005 as well as daughters born before that. And therefore it is said on 9/9/2005 only two requirements present, that is today's law. 3 judges bench of the Supreme Court of India held in the year 2020 in the case of Vinita Sharma versus Rakesh Sharma that there are only 2 tests. 1, property must be available and daughter must be alive. There is no need that father must be alive on 9/9/2005. 9/9/2005 ला वडील जिवंत असण्याची काहीही गरज नाही. प्रॉपर्टी पाहिजे आणि डॉटर पाहिजे. Therefore, Prakash versus Pulvati overruled and Danama is partly overruled. That living daughters of living fathers, that is not the law today, and it is only the living daughters having and holding property is the test to be applied. That is the present law on the point. Friends, however, there is extremity of the application. आपण असं पाहिलं की 37 आधी काहीच हक्क नव्हते, फक्त पार्टिशन, फक्त मेंटेनन्स असे हक्क होते. श्रीधनचा हक्क होता. मग 37 साली काय आलं तर लिमिटेड इंटरेस्ट आला. 17 जून 56 ला त्यांना काय मिळालं तर तो 1/4 3/4च्या फॉर्म्युलाप्रमाणे आमच्या त्या मुलीला तो हक्क मिळाला. मग आता 1994 काय मिळालं, अनमॅरिड डॉटरला आम्ही मुलासारखं ट्रीट केलं. 2005 ला काय केलं, त्या मुलीला मुलासारखे हक्क देऊन टाकले. दिस इज द फायनॅलिटी रिच्ड बाय दिस कॉन्सिक्वेन्स. फ्रॉम नथिंग टू ॲब्सोल्यूट इज द जर्नी फ्रॉम एन्शियंट पिरियड टू द केस ऑफ द लेटेस्ट केस डिसाइडेड बाय द सुप्रीम कोर्ट, and that is in respect of Vinita Sharma versus Rakesh Sharma. हा एवढा प्रवास ह्या सगळ्या ऍक्टचा झाला. हे झाल्याबरोबर there was a case before the Supreme Court of India. There was a case before Delhi High Court. सुजाता शर्मा वर्सेस मनु गुप्ता. दिल्ली उच्च न्यायालयाच्या जस्टिस नजमी वजिरी या विद्वान न्यायमूर्तींच्या समोर एक सुंदर केस निर्माण झाली, एक कॉम्प्लिकेटेड केस निर्माण झाली. आणि इन दिस कॉम्प्लिकेटेड केस ऑफ सुजाता शर्मा वर्सेस मनु गुप्ता, फॅक्ट्स वर व्हेरी सिंपल. That there was a family consisting of 4 members: father, senior member, daughter, then junior member brother, and further junior most member daughter. वडिलांचा मृत्यू झाला. घरामध्ये लग्न झालेली मुलगी ती नवऱ्याच्या घरात राहत होती. देन छोटी मुलगी होती आणि एक धाकटा भाऊ होता. ह्या तिघांच्या मध्ये वाद सुरू झाला. This married daughter Sujata Sharma filed a suit against her younger brother. त्या भावाच्या विरोधात तिने खटला दाखल केला partitionचा. And when she instituted a suit for partition against her younger brother and younger daughter, younger sister, in the event of death of father, वडिलाच्या मृत्यूनंतर लग्न झालेल्या ज्येष्ठ भगिनीनं आपल्या कनिष्ठ भगिनी आणि कनिष्ठ भावाच्या विरुद्ध पार्टिशनचा खटला दाखल केला. Issue was whether this is maintainable or not. And ultimately, it has been held that such a suit is maintainable. She claimed two things. तिने काय मागायला पाहिजे होतं? पार्टिशन. माझा हिस्सा मला देऊन टाका. आय एम अ को पार्सनर. तिने ते नाही मागितलं. तिने सांगितलं की मी को पार्सनर आहे आणि मी या कुटुंबाचा कर्ता पण आहे. फार छोटा इश्यू निर्माण झाला जो तुमच्या परीक्षेत येऊ शकतो. सुजाता शर्मा वर्सेस मनु गुप्ता, दिल्ली हायकोर्ट. आणि इश्यू होता वन लाइन सेंटेन्स, वन लाइनर. Whether a married daughter living in husband's house can be karta in brother's house or not. And surprisingly, by correctly interpreting these provisions, Honorable Delhi High Court has held, yes, a married daughter living in her in-laws or husband's house can be karta in brother's house. Friends, therefore, this oscillation, हा जो घड्याळाचा लंबक होता ना, तो एका बाजूला होता. फक्त पुरुषांना आणि पुरुषांनाच हक्क होते. तो हळूहळू मध्ये आला आणि आता दुसऱ्या टोकाला गेला की आता ह्या स्त्रीला आम्ही हक्क दिलेलेच आहेत. नुसते हक्क नाही दिले, भावाच्या कुटुंबाचा कर्ता होण्याचे पण अधिकार दिलेत. This is the extremity reached by this law. This is today's law according to Delhi High Court. This particular case is pending in appeal to the Supreme Court. And let us see what happens in the Supreme Court in the present case. This is one segment of the discussion. If time permits, I will continue for another 15 minutes. Yes? May I continue for another 15 minutes?
Yes, sir.
Issue is with reference to interpretation of Section 8. How to interpret Section 8? We have discussed that when there is a death, then Section 8 applies, Section 19 applies, and property in the hands of the heirs, that becomes a separate property. Was the question before Avhad High Court in the year 1956. In the year 1956, there was about 55 years back, there was a question before Avhad High Court. If there is a death, if there is Section 8 application, if there is Section 19 application, property in the hands of the heirs, whether that is ancestral or separate property, was the case of Commission of Income Tax versus Ram Rakshapal. In case of Ram Rakshapal, this issue was decided in Indian court for the first time as to application of Section 8 and whether property, ancestral property, becomes separate property or not. And it has been held by Justice M.H. Beg, the judge of Allahabad High Court, who afterwards became the 15th judge of Chief Justice of the Supreme Court of India. Justice Beg then said, yes, if there is death, if there is Section 8, then Section 19, then such property in the hands of the heirs will become separate property. Therefore, the thousands of years old concept, by the virtue of application of Section 8 and Section 19, that becomes separate property. This issue was before various high courts and ultimately before the Supreme Court of India in the case of Commission of Wealth Tax versus Chandar Sen, 1986 Supreme Court. So in the year 1986, issue was before the Supreme Court of India whether if in case of death of a Hindu male, property becomes separate in the hands of the heirs or not. And it has been held by the Supreme Court of India, yes, in case of death of a Hindu, Section 8 applies, Section 19 applies, and property becomes separate property in the hands of his heirs. That is what has been decided as to Section 8. Immediately thereafter, there was a case before the Supreme Court in the year 2008, Bhavar Singh versus Puran, and Supreme Court again endorsed the same view that if there is death, intestate, Section 8 applies, Section 19 applies, property becomes separate property. Ancestral property character of co-parcellary property is lost as far as that co-parcellary is concerned. was the judgment in the year 2008. Immediately within 3 years' time was a case before the Supreme Court of India. And that case was Rohit Chauhan versus Surendra Singh. In case of Rohit Chauhan versus Surendra Singh, 2013 Supreme Court. It has been held by the Supreme Court that in case of death, that may be true, but if there is no death and there is a partition amongst the members of the co-parsonery, then if by partition something comes to the share of a co-parsoner, then that becomes and remains ancestral property. So there were two divergent views. You have to understand, there can be a question based on this. परत सांगतो, जर का मृत्यू झाला को-पार्सनरचा, सेक्शन 8 अप्लाय होतो, सेक्शन 19 अप्लाय होतो, तो झाल्याबरोबर वारसांच्या हातामध्ये जी प्रॉपर्टी येते ती प्रॉपर्टी काय होते? सेपरेट. बाय व्हर्च्यू ऑफ दिस फिल्टर, by virtue of this application of these two sections, the ancestral property becomes separate property. That is the case in respect of Bhavar Singh versus Surinder Singh. However, in Rohit case, it has been said, रोहितची केस वेगळी, ही केस वेगळी. इकडे डेथ आवश्यक होती, डेथ झाली की वारसाच्याकडे सेपरेट होते. Ancestral property by death process becomes separate. Now, in this Rohit case, there was no death, there was partition. उदाहरणार्थ 4 भाऊ आहेत, 4 भावांनी वाटप करून घेतलं, एका भावाच्या हातात इस्टेट आली, ती इस्टेट याच्या वारसासाठी आता ancestral का separate, there is no death and has been held by the Supreme Court, 2013 Supreme Court, Rohit Chauhan versus Surendra Singh. And court said, in case of death, there is a criteria of ancestral property can be separate property. If there is partition, then ancestral property remains and continues to be ancestral. Co-parsonery continues in that case. So, what is the criteria? काय तुम्हाला एक प्रश्न विचारता येऊ शकतो, डेथ झाली तर ancestral property becomes separate property. Hindu Succession Act applies. आणि जर का डेथ झालीच नाही तर there is a co-parsoner and amongst co-parsoners there is partition, then there is no application of Hindu Succession Act. Hindu Succession Act application होण्यासाठी मृत्यू पाहिजे आणि मृत्यू झाला तर ancestral propertyचं रूपांतर सेपरेट प्रॉपर्टीत होईल. आणि जर का मृत्यू नसेल आणि पार्टिशन असेल तर in case of partition this transformation will not happen. Co-parsonary will continue to be co-parsonary and ancestral property will continue to be ancestral. Ultimately, last to conclude, I will say 2 important cases. There were 2 important cases. One was in the year 2016 and other is the latest is 2020. 2016 मध्ये माननीय सर्वोच्च न्यायालयाच्या समोर केस निर्माण झाली. उत्तम वर्सेस सहवाग सिंग. There was a death of a grandfather and property was in the hands of the sons. Grandson filed a suit and claimed that this is ancestral in my father's hand. If there is a death, if section 8 applies, in section 19 applies, whether there is a co-parsonary or not, and whether there is ancestral property being transformed into separate property or not. And Justice Nariman and Kurian Joseph, honorable judges of the Supreme Court, they held, if there is a death, section 8 applies, section 19 applies, and ancestral property becomes separate property. Co-parsonary comes to an end. Immediately within a few years time, within 2020, there was a case before the Honorable Supreme Court. Arshnoor Singh versus Harpreet Kaur is the last judgment on this issue. Arshnoor Singh versus Harpreet Kaur decided by our former Chief Justice of Supreme Court of India, Justice Uday Lalit. And then Justice Uday Lalit, he held that if there is partition, then we will not apply the case of Uttam versus Savak Singh. That judgment by Justice Nariman will not be applicable, but judgment in earlier case will be applicable of Rohit Chauhan versus Surendra Singh. And therefore, they held that if there is a death, then only succession will apply. Then only section 8 will apply. And then that property will become separate property. If there is no death, but there is a partition, then there will be continuance of co-parsonary and ancestral property. Friends, therefore, to conclude, I will say only ask one question. काय प्रश्न विचारायचा? मृत्यू आहे का मृत्यू नाही? मृत्यू असेल, जर का मृत्यू असेल, हिंदू कोपार्सनचा मृत्यू झाला तर त्याच्या हातात असलेली इस्टेट वारसांच्या हातामध्ये सेक्शन 8च्या फिल्टरनं गेली, सेक्शन 19 मध्ये पुन्हा गाळून गेली, दॅट बिकम सेपरेट प्रॉपर्टी. पण जर का एकत्र कुटुंबामध्ये वाटप झालं, वाटपाने गेलेल्या प्रॉपर्टीचं कॅरेक्टर बदलत नाही, ancestral property will continue to be ancestral in the hands of other co-partners. Friends, this was for today. This was in respect of today's discussion regarding co-parsonery, regarding Hindu joint family, regarding interaction between old law and the new law, and various sections to be discussed as per this law. And the latest judgments in respect of Vinita Sharma versus Rakesh Sharma, as well as this judgment just now we discussed in this case. Somebody is saying that what is the last case? Vinita Sharma versus Rakesh Sharma. And the last case we have discussed just now is Arshanur Singh versus Harpreet Kaur, 2020 Supreme Court. Friends, with this I conclude, and again we'll resume this discussion tomorrow evening. And tomorrow evening we'll discuss not this we have discussed theoretically. Tomorrow I will take various sections and I will discuss and share with you one illustration I will tell you, and that you can prepare for tomorrow. I will ask you a question. If there is a scheduled tribe daughter and she files a suit against brother that I have become a co-partner by virtue of section 6, whether scheduled tribe daughter will be entitled to claim protection of section 6 or not. Or say that there is illegitimate daughter, and illegitimate daughter intends to claim share in father's estate, whether she is entitled to claim or not. Such similar questions, such sections, analysis of sections, we'll do it tomorrow. Till then, thank you. Thank you very much.
Thank you, sir. I would like to propose vote of thanks. Am I audible?
Yes, yes.
Thank you, sir. I would like to propose vote of thanks on behalf of Bar Council of Maharashtra and Goa towards today's our chief guest, Dr. Sudhakar Avhad, sir, for enlightening our knowledge about Hindu Succession Act. I would like to thankful to Chairman and Vice Chairman of Bar Council of Maharashtra and Goa, as well as the coordinator of this series, Dr. Uday Varunjikar, sir, for arranging this series for us. I would like to thankful to the all the participants who has participated in this lecture, and all the coordinators who are managing this lecture series. Thank you all. We will see you tomorrow, sir.
Thank you. Welcome.